court has listened carefully to the argument of both the state and the defense. The court has reviewed in detail and in full Rule 46 of the Idaho Criminal Rules. The court has also reviewed the Idaho Bail Act, Title 19, Chapter 29, specifically under 1929-04. It designates that the court may release a person on his own recognizance or set an amount of bail and may impose any conditions of release. In making these determinations, the court shall consider the following objectives. Number one, ensuring the appearance of the defendant. Number two, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Number three, ensuring the protection of victims and witnesses. And number four, ensuring public safety. The court has taken all four of those factors into consideration, as well as all 10 factors under subsection C under the Idaho Criminal Rules 46. And based upon the argument that I've heard here today, the court is going to reduce bail. I'm going to reduce bail to the amount of $1 million. I recognize all of the factors that have been looked at here. One specific thing that the court notes in setting such a high bail amount is that there is a pending court order, and to my knowledge there has been nothing set forth regarding obedience to that court order pertaining to lining the court out with information on where the two children are at the Department of Health and Welfare or at the Rexburg Police Department. So with that, bail will be set at $1 million. If bail is posted, there will also be the following conditions that are ordered. Number one, there will need to be a waiver of extradition signed from any and all jurisdictions to be brought back here before the court. Number two, I'm going to require that Ms. Daybell not leave Bonneville, Jefferson, Madison, and Fremont counties. If she were to leave any of those counties while this case is pending without permission or authorization from the court, that would be a violation of the terms of bond and release. I'm also going to order that there be an ankle monitor that is placed on the defendant. That will need to be all lined out before she's eligible to bail out. It will be monitoring 24 hours a day, 7 days a week as to where the defendant is. And then lastly, I'm going to order as a term of any release or bail that the defendant appear for all court appearances, that she maintain contact with her counsel, and that she abide by all the laws of this state, this country, this county, and this city. Mr. Wood, do you have any questions about my ruling regarding the reduction of that bail?
No, Your Honor.
Ms. Elcox.
Just briefly, Your Honor, does the court have a specific form for the waiver of extradition you would like us to use?
I think the jail has one. Does the jail have a form that they have? If you'll communicate with the jail, I think they do have a form. If not, why don't you submit the one after you've gotten approval from Mr. Wood? You can submit that after she signed it, and the court will review to make sure it meets my satisfaction.
Yes, Your Honor. And do you have, would you like us to coordinate setting up the ankle monitor through the jail, or do you have a specific agency you would like us to use? You
can coordinate with the jail and or the sheriff's office. They'll know that information. They may have someone that they usually use. I'm not sure of that. If you have a preference, you could provide that information to them, and if there's an issue, it can be brought before me for my approval. Any other questions?
No, thank you.